I can hear you.
People
Leslie.
are waving.
Can you hear me?
Yes, I hear you loud and clear. Kingmaker,
All
can
right,
you hear
good.
John?
Yes, I can.
Okay, great. Okay, good. Sometimes, John, for some reason I don't understand, the speakers sometimes can't hear each other, even though everyone else can hear them. So if that happens, and we say, John, we can't hear you, then people log off and log on again, and that seems to fix it. Okay.
Perfect.
Yeah, and Ship's going to be joining us here shortly too. Okay. All right. So what we're going to be talking about tonight is the Supreme Court ruling today on the Colorado ballot case, in which they ruled that Colorado, and indeed any state, cannot prevent a federal candidate for any federal office from being on the ballot in the state's federal election for federal office as a result of the person's being supposedly an insurrectionist or giving aid and comfort to the enemy under the 14th Amendment, Section 3 of the 14th Amendment to the U.S. Constitution. So that's what we're going to be talking about. Now, fortunately, the opinion itself is not very long, and there are a couple of concurrences to it. And so I want to go over all of those with folks. So I'm going to, not start here really in substance for a couple more, maybe another minute while people are joining on. People are joining, lots of people at the moment. So I want to give people a chance to get on board here. So to start with, what I want to say is basically, who we've got on the call tonight. So me, I think everybody knows. If you're here, you should know me. And Ship and Kingmaker are old standbys on my spaces here, all lawyers. But John Reeves might be new to some of you guys, although hopefully some of your followers should be on tonight, John.
Yes.
So, yeah. So for those of you who don't know John is also a lawyer. He's an appellate specialist. I met John. I think I met you during the Flynn.
Yes.
The Flynn situation, right?
Yes, the Michael Flynn mandamus thing. That was what sort of put me on Twitter. I did a bunch of texts after the DC Circuit asked for a response. I tried to explain to the average non-lawyer what that meant, and I think it was Technofog who retweeted it, and that's how I came to know you, and how I got most of my following on Twitter, actually.
Right. Yeah. Great. So John and I have been friends since then. We frequently talk over appellate issues and bounce things around. So he's a good guy. Now, John, tell us a little bit about yourself. You're in Missouri, right?
Yep. So I am in St. Louis, Missouri, although I'm originally from Chicago. I'm a proud Kansas City Chiefs fan. Just want to get that out of the way right now. And I've lived here for I've lived in St. Louis for 25 years. I'm a former assistant Missouri Attorney General, and I'm what you call a solo appellate lawyer. Appellate is what I do. And it doesn't just mean I write briefs. I also help trial level lawyers sometimes with preservation issues, dispositive motions for summary judgment. I'm fortunate that I've developed a bit of an amicus practice at the U.S. Supreme Court. I actually had a case before the court 2 weeks ago in a bankruptcy matter that Justice Alito temporarily granted me a stay in. The court ultimately rejected my application, but just getting that far was great. And in terms of the law I do, it's basically anything and everything. It's not just these politically sensitive, high-profile stuff. I'm a self-described nerd and proud of it. I mean, whether it's something like this or even what most people would consider a boring insurance coverage dispute, this is what I do. So
right.
Yeah.
And so folks know that, hey, Ship, you're in as a listener. Let me send you an invite to speak again. So folks know there are lawyers who do both trial work and appellate work. I used to. My husband does both. And so there are many lawyers who do both trial work and appellate work, but they are two different kinds of skills. And there is definitely a specialized appellate bar. It's not a formal bar. There's no Federal Appellate Lawyers Bar Association or anything like that, but there's a group of lawyers who specialize in appeals, and then there's a even smaller group of lawyers who really specialize in the Supreme Court practice. Most of those lawyers are in DC, John, right? But not all.
Yeah, most of them are in DC. There are a few out there who aren't in DC. It's yeah, that's a fair way to put it. That's a fair way to put it.
Right.
Yeah, like,
Okay.
I would
So
go ahead. I'm sorry. Go ahead. Please continue.
it's all right. Okay. So as you guys all know, Ship and Kingmaker have been practicing law for a long, long time. I've been practicing law for almost 30 years. And John is pulling down the average age here. So I don't know how long you
I've been
how
out,
long you've been practicing, John.
I've been out since '07. I just turned. I don't mind telling my age. I just turned 42 last January. I guess I did my undergrad in '04, my law school in '07. I mean, I guess I'm no longer a young lawyer.
No, you're not a baby lawyer anymore.
But
Yeah.
but yeah.
Yeah.
But yeah, I guess I'm sort of the younger one of this crowd. But
Yes,
yeah.
yes, you are. So I brought John on to help us understand some of the sort of finer details of the appellate practice. So I want to start with that, and then we'll get into the meat of it. So John, so that people understand, because really our audience here, as we talked about before, is mostly non-lawyers, right, or lawyers who practice in different areas. Trying to help people understand really what is really going on with what can sometimes be arcane and complicated legal issues. And certainly nobody's more arcane than the Supremes, right? So, um, all right. So the opinion today came out, and it's a per curiam opinion. So help folks understand. Tell them what that is.
Sure. So a per curiam opinion is actually very common in appellate courts, not just the U.S. Supreme Court. I mean, even where I practice in Missouri, the Missouri State Appellate Courts, the intermediate and the state Supreme Court, they issue things like this all the time. What it is it's just as binding as any other opinion, but it's an opinion that doesn't have any one author, one justice on the court as its author. It's an unsigned, for lack of a better term, opinion purporting to represent the opinion of the entire court. Now, how that gets written can vary. Sometimes with per curiam opinions, one justice does write it and circulate it, but it's labeled per curiam. Other times, multiple justices contribute, and it's just circulated, but it's still circulated as per curiam.
Okay, so the opinion is the opinion of all 9 justices, the main opinion, right?
Well, yes and no. We know here that it's the opinion of at least 5 of them, as well as Justice Barrett signing on to part of it. The other justices, Sotomayor, Kagan, and Jackson, they agree with its result, but not necessarily with its reasoning, which is actually, that may sound arcane, but that's an important distinction as well.
Okay, but in this particular case, those 3 agree with the judgment. They also agree with the main reason that
Yes.
the first opinion is using, just not all of the reasons,
they
right?
fully agree that states that Trump cannot be disqualified by the states. They agree 100% with that. That is a unanimous opinion 9-0, that the states do not have the authority to disqualify someone from running for president of the United States. That is a 9-0 opinion.
Or any federal candidate,
Yes.
the way I read it.
Yes, absolutely. Any federal candidate. And
okay,
go ahead. Yeah.
And then, but we also have the additional 2 concurrences, one by Justice Amy Coney Barrett, and then the second one by the 3 liberal justices, which is written by Justice Kagan, right?
That is written by, it's funny, I was so busy reading it and seeing who joined it, and I didn't, no, believe it or not, it is, funny enough, the way I read this, it doesn't say who actually writes this. The way it says, I literally just noticed this. It says Justice Sotomayor, Justice Kagan, and Justice Jackson concurring in the judgment. it doesn't actually say. Wow, I'm not trying to sound hokey here, Leslie, but I've never seen something like this before. It's a concurring in the judgment that is itself a bit of a per curiam thing in the sense that all three of them are signing on to this as authors, not just concurring. So,
Right.
wow, yeah. Again, I'm not trying to confuse your audience, but that's actually unusual.
Right.
I don't
So,
think,
Justice Sotomayor, Justice Kagan outranks Justice Sotomayor in terms of seniority, right?
actually, no. Sotomayor came first. Sotomayor replaced. No, oh no, you're fine. Sotomayor replaced. Obama nominated Sotomayor to replace Souter, and I think it was 2010. And then when Stevens retired a few years later, he nominated Kagan. So they're all in.
Right. I had that backwards.
Oh, you're fine.
Yeah.
No, you're fine.
Yeah, I had that backwards. Right. So Sotomayor is the most senior, followed by Kagan, followed by Ketanji Brown Jackson on the liberal wing, and that's the way they're listed in this concurrence by seniority. So it doesn't really tell us who the author is, even.
No, it doesn't.
Even the listing doesn't tell you.
And it could have been one of them. It could have been all three of them. I mean, I think that's very significant that they wanted this to be apparently like a joint concurrence in the judgment. Again, I have literally never seen that before.
So it reads to me like Kagan, though, the language,
Kagan,
I would say.
I agree with you there. If there is an author, it's probably Kagan, who is by far among the liberals and even among the justices in general, regardless of what you think of her views, she is an outstanding writer, and I agree that this reads like her.
Okay, so then, as we all know, Justice Coney Barrett is junior to the other three female justices, right? She's more recent than them. Well, except for Ketanji Brown Jackson.
Yes.
Right. But her concurrence, when you actually look at the opinion, the way it reads, you guys, is there's the main opinion, which is per curiam, and then Amy Coney Barrett's concurrence comes after that. It's the very next page, and then after that is the concurrence of the three liberal justices. Okay, so for folks that don't know, John, explain, what is a concurrence? What does that mean?
Okay, so a concurrence, you have to divide these into two separate things. There's a thing called a concurring opinion, and then there's a separate thing called an opinion concurring in the judgment. Now, again, we're getting into what sounds like arcane stuff here, but they're very important here. Justice Barrett's opinion is a concurrence. It's a concurrence in part. She joins two parts of the court's opinion in full. The part concluding that the states don't have authority to prosecute Trump and the general background. She joins those in full. Sotomayor, Kagan, and Jackson, on the other hand, have what's called an opinion concurring in the judgment. An opinion concurring in the judgment says, basically, we agree with the result the court has reached here, but we disagree with the legal reasons for why the court reached this. And if you're a lawyer long enough, you'll run into this where even outside being a judge, you may agree with a fellow lawyer on your partner or another junior colleague of what should be the result in a case or what you need to do, but disagree on the legal reasons. That's very important.
So more.
Go ahead.
Right. So more basically, though, a concurrence means what? A concurring opinion.
That means that you're joining in the rationale of the case and not just the result. Now, Justice Barrett's opinion is limited in that sense. She is joining what she says are parts 1 and 1B of the court's opinion. She's joining those rationales fully. She's saying, I fully agree with those, but she's not joining the rest. She doesn't she fully agrees about the federalism issues, that it's a bad idea, that the states can't have the authority to decide eligibility for federal officers, for the eligibility for election to federal office. But she doesn't think that the court needed to go into the separate issue of, does Congress need to pass its own legislation to enforce this? And
Okay, so why does a justice write a concurring opinion?
Okay, so a concurring opinion can be done for if a justice thinks that there's a particular aspect of the opinion that they're joining that really should be, how should I put this? That really should be emphasized, if you will. That to sort of flesh out, if you will, certain things that are implicit. I won't boggle your listeners down with minutia, but there's a famous instance of Justice Robert Jackson in the 1950s when the Supreme Court issued a ruling on Truman's authority to override a steel industry strike. Justice Jackson's concurring opinion ended up being more analytical than the main court. He did such a good job of explaining the court's reasoning. Most people cited the Jackson, not the court after that. Barrett's doesn't really elaborate.
Well, let's not get into the specifics yet.
Sure,
Okay.
sure.
So Justice Barrett writes her concurrence is one page.
Yeah.
So whatever it is she's saying I agree with the result, but I have some other stuff I want to say also.
Exactly.
All right. And then the liberal justices, they are also concurring. They're not writing a dissent.
Correct.
Right?
Absolutely correct.
All right. A dissent would mean that they disagree with the outcome and the reasoning.
Yes.
And they're writing a concurrence, so similar to Justice Barrett, but they're saying that they agree with even less of the main opinion than she does.
Exactly. They agree. They're saying that they don't agree with the opinion's rationale at all. They fully agree that Colorado cannot prohibit Trump from being on the ballot. I want to emphasize that. They fully agree with that result, but they disagree with the why of it. They disagree with
all right, and I think and that's a point I want to drill down on with the whole group as we go along, because I'm not sure that they really do.
Well,
right?
It's funny,
So
I agree with you actually on that, but I'll you keep going. I'll go into that when you think it's through.
Right. Yeah, and then we can all discuss that issue.
Let me jump in here.
So what
let me jump in here a second, Leslie.
Yeah, go ahead, Chip.
John, my understanding has always been that the what we call the outcome, in this case 9-0 or 6-3, that is only on the outcome. That is the way the justices vote the case should be decided. Beyond that, it means nothing. Beyond that, it's a matter of who joins what opinions and what parts. And that's when you begin assembling where are there 5 votes for the specific details. But the fact that it's not, this is 9-0 to the extent that the Supreme Court of Colorado needs to be reversed. And that's it. It's not 9-0 beyond that.
That is correct. So if you want to really do that. So the Supreme Court of Colorado said Trump must be removed from the ballot because he's ineligible. The justices 9-0 have issued a judgment 9-0 saying we are reversing that decision. That's 9-0.
Right. You're wrong, Colorado.
Yes.
Right.
Now I will add to that there are times when you have justices concurring in the judgment where there isn't a majority. The court's opinion, there isn't actually a majority. It's only a plurality where you have 3 or 4 votes of an opinion, but then it's joined by 2 or 3 others that are concurring in the judgment. And that makes it a problem because it isn't clear what the binding case law is. Now, we don't have that problem here because there's 9 justices on the court, and even if you include Justice Barrett's concurrence along with Sotomayor, Kagan, and Jackson, that's only 4 justices who didn't sign on to the opinion completely. We still have the per curiam opinion still has 5 votes, so that is still binding.
It still has a majority.
Yeah, so we don't have that problem here, but there are times where the justices, they agree on the result, but they disagree on the reason, and literally they cannot form a majority, and that really creates problems then because no one opinion in that case is actually binding case law. You actually have to go through it and try and find the narrowest reasons for it, but we don't have that problem here. So the
Okay, so I have one more technical question for you, John,
Land.
which is the one that which is the one I called you about earlier today. Because one of my very astute followers asked, why is Judge Barrett's opinion come before the opinion by Sotomayor, Kagan, and Ketanji Brown Jackson, when Sotomayor and Kagan outrank Amy Coney Barrett in terms of seniority? Because normally the court does things by seniority,
Yes.
right?
Yes.
So if three justices dissent and they all write separate dissents, the way they are laid out in the papers, the dissent of the justice who's more senior comes first, and then the next senior judge's dissent comes second, and then the last senior judge's dissent comes third. And here, Amy Coney Barrett's is her one pager is sandwiched in between the main opinion and the concurrence of justices who are more senior than her. So explain why that is.
Okay, so there's no hard and fast written rule about this. This is more of an unspoken oral tradition, but if the more you follow the Supreme Court, you realize oral traditions are very important. So the way the court does it is the opinion comes first, then any concurrences do, then any concurrences in the judgment. Remember, I explained earlier the difference between a concurrence and the concurrence of the judgment, and then dissents. Because Justice Barrett has a concurrence where she fully joins at least part of this opinion, that is listed before the three liberal justices' concurrence of the judgment. So that's why that's set out that way. At least that's how I read it.
Right.
And there's really nothing.
Yeah. So basically,
about that.
Right, exactly. So it's basically the more that the concurrence agrees with the main opinion, the higher up. Like they could all nine write whatever they want to write, right?
Yeah.
Yeah. Yeah. Okay. All right. So that's the end of the technical questions. Unless Ship, either you or King have any technical questions for John about the opinion itself. All right. Hearing no questions, we will then proceed to discuss the actual opinion. So King, let me bring you in on this. So, what do you make of the let's just start bigger picture of the what they've done here and what they decided, the main opinion, what they decided to base it on? Because we talked about all the issues that were raised by all the lawyers, and they really have decided not to address most of those.
Before I get down into the weeds of the opinion itself, I want to describe my day.
Okay.
I read the opinion and then watched on social media as a string of liberal commentators and lawyers and professors, all of whom had predicted that
The self-executing 14th
yeah,
Amendment was
that
gonna
the Colorado deal was solid, and they were most distressed that particularly that their three liberal justices didn't go that way, not even those
right.
three. And so what we had was, it was like watching the first act of an opera. I can't tell yet whether it's comic or tragic, but it was a first act of an opera with a chorus, a crying chorus of these liberal commentators, and just on and
Right.
on and on all day long. And I just thoroughly enjoyed myself.
You guys, King started DMing me pretty early on with quotes from the opinion and other what these people were saying. It was hilarious. The one I thought was both funny and really very disturbing was Keith Olbermann. Did you guys see that? He said we should dissolve the court. I mean, what the hell?
He said the three female liberal justices, two of whom are women of color, lack reading comprehension skills.
Yeah, that was spectacular, wasn't it?
Anyway, so you guys see where I'm coming from. It was quite a scene. I'm not sure
Yeah.
where Act
No,
2 goes,
crazy.
but Act 1 was thoroughly enjoyable. I'm not going to leave my seat.
Right. Okay. Well, since King raised that topic, John, you and Ship, did you see anybody else that you thought, wow, that was a spectacular meltdown? I mean, I thought Neil Cottrell embarrassed himself today, personally.
Well, I mean, my personal view is it. Without identifying anyone in particular, I do think it represents a bit of a problem of having commentators going on these big networks. Of course, I could be indicting myself here. I mean, here I am as this, so maybe I'm shooting myself in the foot. But no, it's this celebrity. I mean, look, I take pride in. I love explaining these complex things for non-lawyers. Civil education in this country is so bad now. We need non-lawyers to know how our government works, and in an ideal world, that's how this is going to be. But the problem is, you get certain individuals who they end up loving sound bites, and they're now and a lot. All I'm going to say is this: a lot of these commentators, I'm not going to identify anyone by name, but you listen to what they say on TV, but then you read their legal briefs and their cases, and it's like two totally different people, because they know. And incidentally, and I don't want to get sidetracked with this, but it's precisely to avoid this kind of celebratory soundbite nonsense that the court has been, rightly, in my opinion, resistant to having live streaming and cameras in the court. They release the audio now, or no, they do live stream now. I apologize, but that's why there's no video, and it's a shame. We need good commentators. We need good people who are going to do this, but certain reactions are. Well, I will name one individual, frankly. I have to read his article, but if you look at somebody like David French, quite frankly, no, and it's a shame because he used to be very fair-handed. The problem is
well, we all know what the problem is. He has TDS. So, his article about how this was a solid legal argument, Colorado was going to win. Well, that article is absurd.
It is. And again, if you're not able as a lawyer, and I guess this is, Leslie, you talked earlier about trial lawyers having different skills than appellate lawyers. I mean, when you're an appellate lawyer, emotion is a far less important thing. You're not arguing to a jury. You're not making factual issues. It's what the law says. And one of the things you have to do as an appellate lawyer is, and I don't mean this in a bad way, you have to become almost like a human iceberg when you're looking at the issues. You have to put aside, I mean, don't get me wrong, I'm passionate about the causes I argue for, but you can't let your passion override your rational faculties. And I do want to commend the liberal justices, and we're going to get.
I was just fixing to say that. That seems to be what the main problem with a lot of these commentators is they expected those liberal justices to not override their passions, and they're terribly upset that they didn't.
Exactly, and it is a problem when people have a problem with this when they don't rule the way you want them to. I mean, to give an idea of how much things have changed. Back in the late 80s, by contrast, when there was the whole flag burning issue, the really young listeners won't remember this. It was long before they were born, but is flag burning protected by the First Amendment? And Scalia had just been voted onto the court, and he joined the majority that said it's not. It is protected, and people were stunned. But Scalia always said that, being a justice, he sometimes has to make decisions he doesn't personally like. Your personal views are, or they should be, irrelevant.
Okay, so let me let Ship join in here. Did you see any particularly spectacular meltdowns that you liked today, Ship?
I have to confess that I had a somewhat busy day, and I didn't get a lot of chance to monitor social media in real time.
Oh, that's all right. That's all right. We all know you're doing the work that needs to be done for the J6 folks. So I just was curious if you saw anything that you thought was particularly interesting. So, all right. So let's go back to King then.
Back to the nuts and bolts of what they did. it was obvious to anybody who listened to the oral argument that this court was going to go either 9-0 or 8-1 in to overturn the Colorado decision. There were several legal theories that were put forth by the justices. The one of them by Justice Jackson kind of signaled that the liberals were even against it. Was that you can't have a patchwork of states, red states versus blue states, kicking people off of the ballot. And leaving the decision of who's going to be the next president to about 4 or 5 or a handful of states who were left out of that.
Right. The ones who are left over and
Yeah,
are purple or
right.
something. Right.
That just will not work. And so it was obvious that the idea that states, individual states, no matter how they got there, had the ability, the power to force or rule or decree that this candidate versus that candidate would be off the ballot because they're an insurrectionist under the 14th Amendment. Is the
So
last
that's
thing
a
you want.
practical
What's that?
argument.
Yeah,
Right. Yes. That's a
that's a
practical
and
argument, really. Yeah.
when that came out and nobody pushed back on it, it was clear we're going to get a reversal.
Right. Now that's not really the reason that they ruled the way that they did, though.
It's not,
Right.
but
So yeah.
it's the theme of the
Well, the reason that they
right.
said,
It is
let's put it that
actually
way.
it's the theme of the 3
Yeah.
concurring justices was just
Yeah.
that. But the legal reason the court used in the per curiam was that 14th Amendment has some subsections. Subsection 3 is the one that contains the insurrection clause. It says, uh, uh, in general terms, somebody who has committed an insurrection against the United States cannot hold um,
A whole bunch
an
of
office.
offices.
And then they list
Let's not go down
right.
that road
We're not going
anymore.
to
Right.
argue all that, but basically it says if you're an insurrectionist, you can't hold an office. Section 5 has a provision that says Congress is authorized to pass laws to implement the provisions of the 14th Amendment, which would include Section 3. And basically what the court held was that the structure of that, and as it's written, does not permit the states to do it. The states, this is a federal function to knock somebody off of the ballot or out of an office under that clause. And
They took a pretty high level
yeah,
view, I thought, of the
right.
amendment. Like they've explained that the 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 main purpose of the 14th Amendment, which is one of the Civil War amendments, was to take power away from the
Yeah.
states.
Yes.
Right?
And
Right.
that which is the point that the liberals made during the argument that this and I think it got their attention when the Trump's lawyer emphasized that this not only the whole purpose of the 14th Amendment is to limit the power of the states when it comes to things like civil rights, and for years, for these civil rights lawyers have basically made their uh, it's been their stock and trade to fight against so-called states' rights and in favor of a federal notion of civil liberties. And the the
Let me explain this to people who I'm sure don't know. But the 14th Amendment is where the Equal Protection Clause is. It's also where one of the due process clauses is. So there's due process clause in the Fifth Amendment that applies to the federal government, and then in the 14th Amendment, the amendment applied due process to the states. Can you mute yourself for a
sure.
second, please? Um, and so this is one of the ways they took power away from the states because they wanted the states to not be discriminating against blacks, right? The equal protection has been applied to not just blacks, but for example, to women. So the structure of the 14th Amendment is that it moves some power that previously resided with the states to the federal government, or another way to look at it is that it allowed the federal government to impose legislation on the states that without the 14th Amendment wouldn't have been otherwise authorized by the rest of the Constitution. So that effectively takes power from the states and moves it to the federal government. So within that's the essential framework of the entire amendment. And so within that is Section 3, which talks about this idea of insurrection. So the main opinion basically says it doesn't make any sense for Colorado to say that they have the power to remove federal law candidates from the ballot, that somehow they're authorized to do that by the 14th Amendment, when the whole point of the amendment was to take power away from the states, not give it to them. And it makes even less sense to say that the amendment somehow silently is the word that they used, that by implication or implicitly, or by not expressly saying, but the opposite of that, by silently giving power to the states, that makes even less sense. So they really looked at it from a structural point of view first, and said, "This, we think this is why the states don't have the authority to do that." And then the rest of the opinion is like a explanation of kind of like why that makes sense in other ways. So, King, what did you? I mean, this was not this particular sort of structural argument wasn't really mentioned very much in the oral argument, as I
It was
recall.
towards the end. Justice Jackson brought that up. That they
Yes, she was
She
the
actually
leading
was,
proponent of it. Yep, right.
and uh, I think that's what got all nine of them together. Where they parted ways was in the details of the specifics of the language and structure of the 14th Amendment itself, and particularly Section 5, which authorizes Congress to enact laws to implement the provisions of the 14th Amendment, carry out those provisions. And the the main opinion, the per curiam opinion, uh, that at least five justices seem to agree with, said that section basically Congress is the this insurrection clause doesn't work at all unless Congress passes a law to implement it and provide who and how and where and by what process somebody is held to be an insurrectionist. Uh, and they go back through the history. They said after the 14th Amendment was passed, you had uh, a specific law that was passed in early 1870s. I forget the date, but it had specific provisions establishing the right to go to court in what they call a quo warranto proceeding to uh, uh, attack somebody who's been elected to office but who is accused of being an insurrectionist. And you basically file a complaint in the courts uh, attacking his right to hold that office because he doesn't qualify. And then it's left to a trial and a decision by the court. as to whether he's to be kicked out or not. That law, and then there's a companion law concerning criminal liability for insurrection.
Right. Now, the Congress repealed the quo warranto, but they did not, well, they kind of recodified the
They,
criminal section or rewrote
yeah,
it in the
in 1948,
40s.
they recodified the criminal. The opinion says they're not sure what happened to the quo warranto. They can't find it.
Right.
Literally,
Right, exactly.
the opinion says we don't know what happened to it.
Right. And what was interesting is they then did not pick up on that separate amicus brief that we talked about before, where a local lawyer identified that that quo warranto provision is still existing in the DC code, even though it isn't in the federal code anymore. So it looks to me like they just decided to ignore that.
They ignored it and just assumed that it doesn't exist anymore anywhere. And except on the criminal side, there is a specific criminal provision that makes it a felony for somebody to engage in insurrection, and which requires a indictment and criminal trial before a jury before somebody is held to be an insurrectionist. And that
Right. This
yeah,
is
that law
in
specifically says
this
that
is
if you're convicted, you're prohibited from holding federal office.
it says under the United States. So there might still be an issue there about the president, or maybe not. But right, that provision is very specific. It's in 18 USC 2383. So it's in the criminal title of the US Code, if folks want to look it up. So that the way I read their opinion is that that's the only extant federal statute that applies. Um, so then they went on to say that if they're to otherwise to figure this out, the Congress would have to pass a statute. Now, let me turn to you and John here. I know John read the opinion. Ship, did you have time to read the opinion today?
I probably did not read it as closely as I need to. I did listen to some commentary of others who tried to decipher and deconstruct the
Yeah,
opinion,
right,
and somebody asked, I was just asked on Twitter early, what did I think that they were trying to accomplish in going down the path? And I just
right,
off the
exactly.
top of my head, and I think it turns out I'm probably pretty close. Off the top of my head, as I thought, my reaction was, I think the court is signaling they are shutting down this path of election
Right.
disputes. That they are not going to let the courts be drug into all manner of controversies about eligibility. That this is ultimately a question for the political branches. They need to figure it out.
So this gets me to a specific point that I wanted to ask you guys about. So when I read the opinion, John, you tell me what you think about this too. When I read the opinion, they were talking about the Section 3 and how Section 5 works and what legislation the Congress has in the past passed and what's currently existing, which is just this one section and so forth. And then they say, so, Congress would have to write a statute that says what the procedures are in order for this to happen. And they link that to the problem that they see, which the liberals seem to agree with, that if you let the states do this on their own, you'd have 50 different systems all work in 50 different ways, trying to arrive at this conclusion of whether people are insurrectionists or not, and therefore applying the section. And the majority opinion or the per curiam opinion seems to be describing that Congress would have to write a statute as a way of making their decision make more sense. When I read it the first time, I didn't read it as this momentous ta-da, and oh, by the way, Congress, you need to write a statute to address this because otherwise there's no way to do it. But that's certainly the way a lot of commentators are reading it. John, what was your take on it?
So I do agree. This actually goes to the fundamental disagreement that the liberal justices and Justice Barrett actually have with the majority opinion.
Right.
You can hear me okay? By the way, my feed was starting to slow down. Okay, good.
Yeah.
What the majority is saying is that this provision, the disqualification provisions of Section 3 of the 14th Amendment are not self-executing. Congress has to pass what's called enabling legislation, setting out how they're to do this, what the procedure is to be to disqualify somebody. And you've seen this historically in other 14th Amendment contexts. The court talks about how in 1870, the court during the construction, I think called the Ku Klux Klan, to help enforce sanctions against the Ku Klux Klan. That statute, by the way, incidentally, the court doesn't mention this, but that statute is the basis for what is today's Section 1983, which is the statute that allows you to sue state officials for money for violating your civil rights. The 14th Amendment gives you the ability to do that, but by itself doesn't give you the right to sue someone for that. Congress had to pass a law for that. That's what the court is saying here. Now, the liberals and Justice Barrett are of the opinion that the court didn't have to go that far. Their view is, the court they're not necessarily disagreeing with the court's analysis of that. They may be right, they may be wrong, but their view is that the court did not have to go that far and say Congress needs to pass enabling legislation.
In order to decide that Colorado doesn't get to.
Yes. They would have said, they were like, what the court should have just done was say, look, we have a federal structure constitution, and
we hear your little one. Yes, John has some little ones at home, you guys.
Yes, that's the nice thing about living in a home office. So we have one moment. I apologize for that. I have a very eager 9-year-old. The opinion talks about how we have a federalist structured constitution. The states don't have certain powers to govern elections to federal office. The liberals, along with Justice Barrett, were of the view that that's all you have to say in this opinion. Just that, the structure of our country, you can't have the states decide eligibility for federal office because of legal inconsistencies. They see no reason why the court then had to go the additional step and say, for Congress to address this, it has to pass enabling legislation. They would have left that for a later case to decide. Which, to be honest, I can see the merit in both positions. And that's the other thing. I won't take up too much of your time, but I want to dominate this. But I'll just say that's what I like about this opinion, to be honest. The positions that the dissenting justices take, this really isn't a conservative or liberal view. These are what the majority adopted and what the dissenting justices said over whether they should have addressed whether Congress needs to do enabling legislation. This is a legitimate question that doesn't have an easy answer that reasonable people can disagree with. This isn't a liberal versus conservative issue. And that's what I like about this, frankly. It's a genuine good faith disagreement. It's how the court is supposed to decide cases. That's what I would say.
Well, let me ask King. King, do you read the per curiam opinion as saying that the Congress passing a statute is the only way that the federal government can disqualify, and as being necessary to the opinion, right? Because in what I think is Kagan's writing, the only example of why that wouldn't make sense that she seems to give is that what if a defendant wanted to disqualify the prosecutor who was prosecuting him because that person was an insurrectionist and shouldn't be in federal office, which seems like an allusion to the Fannie Willis situation to me, to be honest. But that's the only example she gives up where gives that you would you have legislation that would authorize that? Why couldn't you ask a federal judge to do it on some circumstances is what she seems to be
That's
saying.
exactly what she's saying. That she doesn't use examples, but she says there are other means under the federal system that might be possible to accomplish the same result without getting Congress to pass a law first, telling us how to do it. Uh, the the per curiam was very clear. It thought that uh, Section 5, and it's the way it works in the scheme of Article of the 14th Amendment, uh, requires Congress to make that call first, pass the legislation, and to implement the terms of the provisions of the insurrection part of section of article. The 14th Amendment. So, on the one hand, you've got the per curiam opinion that says we can't let the states do it because functionally it won't work. We'll have a patchwork that cannot operate in a federal system without destroying the way we elect uh, uh, presidents and other officials. Uh, but there's another reason, which is Section 5. The 3+1 who did not sign off on that thought they didn't have to go that far. Just as a matter of almost as a matter of principle, you can't. They did not give an example of how it might work otherwise.
Right. The only one is Kagan's.
Yeah.
It's a one line about what about a defendant who wanted to
Right.
disqualify a prosecutor. And you have to kind of read between the lines to get at what she's getting at, which is that would be putting
Yeah.
it before a
Yeah.
judge rather than the
Yeah.
Congress.
The
So,
main opinion makes it clear that it adopted the rationale from Griffin's case, which was decided by
right.
Justice Chase, Salmon P. Chase, back in the 1860s, 1870s, I guess, before he was on the Supreme Court. And it was, for years, it was kind of accepted as the blueprint for how this would work, but the court had never weighed in on whether actually it was law.
One thing I noticed was that the procurement opinion relies heavily on a case called term limits. And that is a case in which they decided, the Supremes decided, now it was a different configuration on the court, but they decided that you could not, states or otherwise, couldn't impose conditions to hold federal office beyond those found in the Constitution. Like, so for the president, you got to have the age requirement, you have to have been a natural citizen, etc. And that the states and others can't go beyond those qualifications and impose other ones. So if you look at it from that point of view, I mean, I was really struck by how many times they relied on that one precedent. If you look at it from that point of view, then Congress is the only body that can do this disqualification thing. And it's only authorized to do so because it's been specifically empowered by Section 5 of the 14th Amendment, which is in the Constitution, in order to do the disqualification. Do you see what I'm saying?
Yes, and which left the I call them the minority. Really, what they fell back on at the end of the day was the fact that the 14th Amendment has been held, particularly the civil rights provisions in the 14th Amendment, have been held to be self-executing. They create the law that states are bound to apply equal protection to all citizens, and that that is a law unto itself, and it doesn't need Congress to do anything to make it the law.
Yeah, except they're not right about that, right? I mean, John already gave us the example of you couldn't sue the federal government even after they passed the 14th Amendment until Congress passes some of the civil rights legislation.
And in
So,
disqualifying a candidate for office because he committed some offense against the United States, it raises